Good afternoon, everyone. Thank you for joining us. Today is the 14th, am I right? The 14th of January. How the year flies. I remember on New Year's, we were all in lockdown and we were all at home. And now we're back at work. Okay, wonderful. Thank you for joining us. With me today, I have Daniella Mair, a psychological counselor, a psychologist, someone that specializes in family matters, family issues between husband and wife, family, children issues, and so on. Daniella, how are you doing?
Hi, very well, thank you. Very excited to get cracking into a great 2021.
Wonderful, always wonderful to have you, always positive. And Daniella, I must tell you this, I done a custody battle now last in December. We were successful. I won't deal with much of the details in the matter, but the court specifically referred to one of your reports. And based upon your report, it was one of the supporting documentation. So what I'm going to is the great work people like yourself, psychologists, psychological counselors do, the courts do take note of what you're doing. And I was very grateful because of your report, it assisted us. I'm not saying because we won, or specifically because of that, but it definitely assisted us. And maybe without the report, we would not have done that well. So thank you for that. Daniella, it's December time. I'm the most busiest regarding custody matters in December, just before December and January time. That's where people fight over kids. What are your experiences?
You know, December period especially, there are a couple of holiday periods during the year, but especially December with the extended holiday with the kids, it always becomes a nightmare. And this seems to be a period where people conveniently forget what they had discussed in their parenting plan. And we deal with, I think generally we deal with new divorce cases and new parenting plans, but we forget about the fact that we've got parenting plans that are documented that might be 10, 15, even 8 years old, that people don't necessarily refer to continuously. And I think that it's quite important for people to remember that when they were going through it in the beginning, that the parenting plans were drafted for a reason. They can be amended at any time, and the onus is really on the parents and for the children to see what would best suit them as they grow up. But because of this, people often forget that they had come to an arrangement a couple of years before, and it causes major issues. So December for me is non-stop phone calls about who should be having the child on Christmas Eve or on Christmas morning, or all that kind of stuff. So very busy, very difficult.
Now, I remember myself on Christmas Eve, I was, a few years ago, I think on Christmas Day, I was in the High Court dealing with a custody matter. And on the 23rd of this year, I was also dealing with a custody matter in the High Court as well. So we were quite extremely busy at the time of the year, and people have a lot of issues. Daniella, we need your advice, we need your assistance. Today's topic is family mediation and parenting plans. A very serious topic. Many people in South Africa, they cannot come to an agreement regarding parental rights and responsibilities. They have problems regarding contact and care issues. And the solution, and honestly I believe the solution is not litigation at the start. Litigation comes at the end like doing the operation. The solution at the start is mediation, facilitation, parenting plans, and that's where you come in. We have a link on screen now. It's www.ourlawyer.co.za/pp. If you are watching this video, please click that link immediately. A PDF of a parenting plan which Daniella drafted and which she works with will be downloaded onto your PC, and you can follow through this. And the next few minutes time, Daniella will explain to us that specific parenting plan and how it works. But Daniella, before we deal with that specific aspect, parenting plans, how often are you called upon to assist people in drafting parenting plans?
So as I've mentioned in previous webinars, is that I run a family therapy practice. I do the family therapy side, and I do mediation because I'm an accredited mediator. And to be honest, out of my schedule, I would say that at least 70% of my clients approach me for parenting plans. So the one thing is, the one type of client I get, like I've mentioned before as well, are people that want to go through a divorce and they know what's going on and what's best for the children, so they approach me to help with that. The other side are people who go immediately to the legal route, and then the lawyers or the advocates or the magistrates or whatever advise that a parenting plan needs to be drafted, and this usually comes up in the middle of a legal battle. So I just want to mention quickly before we get into a parenting plan how important I think it is to actually understand the process from start to finish. And I've actually had a couple of clients already this year who have approached me to kind of have a session just to explain what they can expect should they decide to go through the divorce. So I think that's quite valuable to know exactly what is going to happen before you even start, because I feel that the clients that I have who are sent to me by their legal representation come already with their backs up. You know, it's almost like the chaos has already started, the chaos is all around. Now they're going to come to a mediator and try and remain calm. So I think that initially, if you understand what you're in for and what your options are, and you decide to come mediation before you go legal, that there's a lot of benefit in that in terms of being able to keep the process relatively calm.
I just muted myself. Yeah, I see the only time it makes sense to go to court before a parenting plan gets agreed upon is when the matter is urgent. Let's say one party has been refused contact and the child is in danger, or the child is being neglected, and we do not have time to mediate this matter. The mother is, for argument's sake, being irresponsible. She is leaving the child with a third party while she's partying at night. The child so it makes sense. We go to court first. We first get an order in place stipulating causing some stability. Either the minor child should be placed in the care of a third party, or by the father or the mother, as the case may be. Then we postpone the matter for an investigation, for mediation, for a parenting plan, and so on.
Exactly. And I think it's valuable just to say that there is the option of setting an interim plan. It doesn't have to be set in stone. And if, like you say, there is a case of urgency, let's just call it neglect, for example, then absolutely the only way to get it resolved for the best interest of the child is to go to court, to get an interim plan in order while we can sort out what's really going on, because that process can take months to do the correct investigation, the correct psychological assessment, evaluations, until we can actually get a proper a parenting plan that we can actually make an official plan.
And Daniella, my understanding of how parenting plans work, you cannot force the parties to agree upon a parenting plan. The reason why I'm saying so is many people, they email me or they phone me or they contact us and they say the father does not want to sign the parenting plan. And I say, yes, full right not to sign the parenting plan because you want to have primary care and he wants to have primary care. You can't force the people. But the benefit of the mediation process and seeing a professional like yourself, people start speaking as people start listening. And if husband and wife, a father and two ex-partners or ex-spouses or lovers, and if they are entwined in heat, if they're angry with each other, they don't listen to each other. They one speaks and the other one speaks, but nobody listens. But with a professional like yourself, a psychologist, you can assess the matter. Father, you speak first. Mother, did you hear what he says? And then the results becomes much better. So for argument's sake, if the parties are like 90% away from each other, the bare minimum that will happen from a successful mediation, although it's not ultimately successful because the parties still go to court, would be that the people are maybe like 50% away from each other now, as opposed to 90%. So there are benefits.
Yes. There are definitely benefits. And also a third part, like a professional mediator, is also there to keep you on track, and I think that's very important. And I think that when a couple goes through any process that's uncomfortable, be it mediation, be it legal, they forget what their end goal is. It becomes, I need to win this, and it's self-preservation, and it might be a little bit of bitterness for why there was a breakdown in the relationship to start with. So it's very important for somebody to keep them on track and to remind them that we're actually trying to sort out the best situation for the children, whoever might win or lose. But as a mediator, we like to say that both parties will leave the session a winner, because as you've said, you cannot force somebody to agree with you. You cannot force somebody to sign a legal document if they don't agree with it. So that is where the trickiness comes in of the mediation process. But I mean, mediation is also not just necessarily a one-shot success story. So it might be that it's involved with a lot of therapeutic realizations and a lot of therapeutic methods that we use in order to be able to disarm the couple to be able to put them on an equal footing in terms of the respect that the mediator will show them. You guys are equal in my eyes. There's no point in you trying to belittle your spouse in front of me, because it's not going to work. So let's keep you level and equal. And from there, you can each have your say. And yes, we check things like, have you heard what she's saying? Have you heard how this affects her? Are you willing to do something to change the behavior? Do you think this is good for the child to be witnessing this and that? And then they start to realize, nobody's threatening me here. Nobody's telling me I'm wrong. We're just trying to get to the bottom of it for the child. And that is quite successful.
Yeah, the interesting thing is, if you as a professional person ask that question, do you think it's in the child's best interest? Do you think it's reasonable? If you ask it, the person will ponder and consider it and apply their mind. But if the other party asks that person that question, oh my gosh, then chaos, erupts. How can you ask me such a question?
Exactly. The other parent is there. In the eyes of the one parent, the other parent who's now questioning you, their only motive now is to attack you and to break you down. All reason, all understanding, everything is out the window. It's just about, I now feel threatened and you are trying to attack me. So don't even open your mouth. I'm not prepared to listen. And when I do listen, I'm not going to hear what you're saying. I'm going to completely misconstrue everything, because I'm not letting you get the better of me. And I see that so often.
And it's funny because, we deal with a lot of professional people. I'm an advocate, you're a psychologist. But many times I see clients who are professional people, like, I won't mention names, you're professional, but highly professional people, and they act like children. And it's funny because they're acting like they're back in high school. So when they met the other spouse, they were very mature. Let's say they met each other at 25 years old. Things went very well until 35 years old. Now they have problems. All of a sudden, they start acting like kids. And they're becoming irrational, illogical. So Daniella,
my favorite thing, ego.
Yes. Now, and ego is a big problem we have. And sometimes ego makes us lawyers very wealthy. Not wealthy, make a lot of money because our client just wants to litigate based upon ego. And that's not right.
But it is right in the sense that when it's needed to get for your career, for what you're doing, then fine. But when it comes to matters that are there to kind of like protect you and your family and your loved ones or whatever, friends, any relationship, then there's no place for it. But it's a natural human characteristic. So, I mean, we're not going to change it. We just need to learn how to adapt and deal with it properly.
Yeah, you're 100% right. I mean, you're looking at case law, cases, court cases. I mean, custody battles has been happening for the last few hundred years, so it's standard. Yeah. So, Daniella, let's move on to your parenting plan. If you are watching this video, unfortunately, we didn't set up the Zoom whereby Daniella can share. I know she can share it via Zoom, but then it causes problem with streaming on Facebook Live. But Daniella, you can maybe go through the parenting plan on your PC. Whoever's watching this video, please download it and let us work from there. If you are watching this video in a few days' time, when the video starts, please download the link. ourlawyer.co.za/pp. Daniella, the ball is in your court.
Okay, so what I've done is I've just put a draft, like a template of a parenting plan. This one is a parenting plan that I actually did draft for a client. So where I had the client's details, I've now just changed to mom and dad. And I've just put a couple of X's in place of certain information. So I'm just going to go through it very briefly. This is a very brief one. It happens to be for a couple who had one child, and it was very amicable. So there was no need for like any in-depth clauses or anything like that. But basically, we need to remember that this is a legal document. So at the top, you can see there, obviously, for which regional court it is addressed to. And then a parenting plan, once it's signed and agreed upon, then gets annexed to the final divorce order. So the case number that is over there is the case number that you get for your divorce that you filed. Okay, so just very briefly, the most very important thing is obviously to identify all the parties involved. So we have mom and we have dad and we have the ID numbers. Sometimes we have a situation where we name the mother and the father, the plaintiff and the defendant. I see that more often in cases of domestic violence or abuse where there's a case opened against one of the parents. So obviously, if the mother goes and files a domestic violence interdict against the father, then the mother is the plaintiff and the father is a defendant. So that is why that may come up. What is very important, though, is that that is not always the case. So when I do have clients that come to draft a parenting plan amicably, the words plaintiff, defendant, all of that kind of stuff, we obviously stay away from because we don't want to put one against the other. Okay, then what we do is, in the parenting plan, we identify the children, also by name and by identification number, and then we'll just list how many children there are, what their ages are, etc. Sorry, I am looking at my draft on my phone while I'm talking. That's why I'm losing eye contact. But what we've discussed before is the parenting plan is there to take care of a couple of issues, one being rights and responsibilities, number 2 is care and contact, and number 3 is maintenance. So under rights and responsibilities, this is going to now address everything that is related to the rights and responsibilities of the parents. What we are saying here is that both parties, what I've written here is that both parties agree to the following parenting plan, and they have these particular rights and responsibilities. A parenting plan is not A to Z template following by the book at all. It is not set in stone. And if anything is irrelevant to your particular case, then we don't include it, obviously. But just as a general go-to, we say here in this one, we've said that both parents will retain 50-50 rights and responsibilities to the child. And under that section, we then break it down further into what are the rights and responsibilities that we're talking to. So things like major decision-making about schooling and tertiary education, mental health and medical care. So what is going to happen in the instance that this child needs medical attention? Both parents have equal right to their opinion on how that should be dealt with, equal opinion on which school the child should go to. So when you sign something like this, we realize that it's not just because mom's primary caregiver and the child resides primarily with mom. That doesn't mean she can now go and choose whichever school she wants to without the father's consent. And I go on for a couple of points. I just want to check if there's anything that we should mention further. Decisions that are likely to significantly change the child's living conditions. So this is something like, let's say mom is primary caregiver and all of a sudden now she's met a new man and she wants the children now to move in with her and the new husband. That is something that the father does have a right to an opinion on, because that is significantly changing the living arrangements of his children. So whenever we have something where the father or the mother can now come and voice an opinion on, we always hit another stumbling block. So we sign it, everything's fine. No, don't worry, that's never going to happen. That's never going to happen. We don't need to deal with it. Eventually it does happen. My phone rings. Now we have to sit there and we have to address that little issue and mediate again one of the points of the parenting plan. So why I mention that is that just because we have the parenting plan doesn't mean now we're all set and nothing's going to come up again. So if you go down further, I'm just jumping a bit here, you see that we put in the parenting plan a clause that should there be any dispute going forward in the terms regarding the terms of the parenting plan, that a FAMAC accredited mediator who is then named will then be called on to advise around the dispute and to hopefully come to an amicable resolution around that. So what that means, parents have now signed that should they get into a situation where they can't agree on something, they take it upon themselves to make the appointment with the mediator that's specified in the plan to help them resolve the issue. What is not, sorry, my little kitten, I'm going to say hello, okay, goodbye, thank you. What happens is if they cannot come to an agreement with a mediator, another clause that we add, which I don't have in this one, is then the nomination of a parenting coordinator. And again, like I've mentioned previously, a parenting coordinator is like a mediator, but have a little bit more scope of power and a little bit more involvement. So a mediator is there to sit and say, what should we do? What do you want? What do you want? We can't agree. Sorry, no, we can't agree on this. I don't like that. I don't like that. We then go to the parenting coordinator, who will then hear it out in a similar session to mediation, similar style, but then it is the parenting coordinator who will then generally have the final say and say, I've heard you, I've heard your mediator. This is what I believe is in the best interest. This is why I believe so. And then can issue an instruction that this is how it's going to be. However, a parenting coordinator can create a mandate, can make an order. However, you cannot enforce that. And that is then in the process when we've tried the mediation, we've tried the parenting coordination, I've set this as what is going to happen, you refuse to do it, I cannot enforce, and then we go back to court and back to lawyers. And this is the cycle of how mediation, parenting coordination, and divorce attorneys continuously grow, unfortunately, with the couple that got divorced 10 years ago. Then, further from that, I have put in this one, okay, plan is special occasions. To address children's birthdays, we need to address parents' birthdays, Mother's Day, Father's Day, Christmas, Easter, Hanukkah, everything that might be special to you. Let's say one parent particularly loves Valentine's Day and wants the children on Valentine's Day, even though that's not normal. That's not something, and that's not a day that we consider a family day. If that is important to a particular person, it must be put in the parenting plan, because without a doubt, that's going to cause a problem sometime along the line. So I would be very happy to draft a parenting plan. This one is 6 pages and very basic. I'd be very happy to draft a parenting plan that was 150 pages if it covered everything that was important. We don't want to get to the 13th of, when is Valentine's Day? The 14th of February. 14th. We don't want to get to the 13th and then all of a sudden have an issue because nobody thought about it or no one discussed it, you know. So we need to break everything down. And usually mother's birthdays, in a perfect scenario, the children will be with the mother and with the father on his birthday. Children's birthdays is usually split. Christmas, Easter, all of that is usually split, equal. And it's nice to also have a little bit of additional information where we can say, in 2020, Dad had the kids on Christmas Eve, Mom on Christmas Day. Therefore, 2021, Mom will have the kids on Christmas Eve, Dad on Christmas Day. And it just seems like so much admin and so much foresight. Like, why do we need to say what's going to happen in 2025? But if we do it in the beginning and just get it done, we will have no issue, because then Dad says, oh, but I want them this Christmas Eve and I'm not budging. At least we've got the paper to go back to and say, but we've already agreed on it. You actually are not within your rights now to come and complain about that. Okay, so that is special occasions, anything that might cause an issue to you. If you have been in the relationship for a while and you know what bugs the other parent on a personal level, then it's also a good idea to just actually sit and address those things, because we don't want any issues to come up in the future. So if it is an issue for the father that he does not like the GP, for example, does not like the child's doctor, does not want to take the child, doesn't mind the mother taking the child to the doctor, but he's not going to. It is completely impractical to have that person as the doctor, because God forbid what happens is the child gets very sick and is with the dad. We know that he doesn't like this doctor. I mean, this is the most ridiculous example I could think of, but it's going to cause an issue. And I guarantee they'll take him to the doctor because he has to, but then it's going to start an argument afterwards. So let's try. We've already now told each other how much we hate each other and how much we want each other out of our lives. Let's deal with everything now, you know, so that the kids don't have to deal with it in the future. Sorry, that was a really terrible example, but okay, so we dealt with rights and responsibilities. We then go on to care and contact. And this is usually a bigger gray area than the rights and responsibility, because those are pretty specified legally. But here is where we obviously now stipulate exactly when the child is or children are going to be with each parent. This is difficult always, because each parent usually wants as much time with the child as possible. So when mom comes and offers the dad one night a week and every second weekend, He's like, but how is that fair? Because that means that you get 4 nights in every second weekend, and it's a problem. So this is really one of the points where we have to listen to what each parent would like if it was an ideal world and it was all up to them. And then we try and negotiate back. So each parent wants 4 days a week and every second weekend. Let's see how we can break that up more evenly, obviously with the focus on what is best for the child. Perhaps the child has a better relationship with the mom and can only handle being away from her for 1 night. That is where a mediator will then come in and say, yes, I understand, Dad, that you love your child. But unfortunately, this child is only 2 years old and relies so heavily on mom that it really will be out of the realm of her well-being for her to spend more time with you at this point. And we remind our clients that, and we actually even put it in the parenting plan, that this can be amended from time to time. It is not set in stone. You've signed it, it becomes an official court order. But circumstances change, children grow up, relationships change. Boys at some point, when they're 2, they need their moms. When they're 13, they need their dads. And we can't say that because this is what we decided when the child was born, that is now what's going to happen until he's 37 years old. So there is leeway. And if anybody feels that it is time or necessary to address the terms of the parenting plan, then they can go back to the mediator and say, things have changed, this isn't working, that is working, whatever the story is, can we please discuss it? And then we just add an amendment to it. So that is important to realize, is that if it is necessary to give up additional extra time with your child because it is in their best interest, that doesn't mean that you're doing it forever. That means that you're considering your child and that you'll still maintain the contact. But as the child needs you more and more, you will get that access and you will get that time with that child because it is all about them at the end of the day. So once we have decided on all of that and on who's going to have care and contact when and how, we can put all of that in. I like to include things such as drop-off and collection. Sometimes parents have such a terrible relationship that it just causes way too much animosity and tension for the child, for the father to arrive at the mother's house. I had a client that used to phone me every time he got to the mother's house to say, I'm here, please let her know, because he would not go and ring the doorbell. And that's crazy. So what I did in that instance is I said, you know what, instead of now going and fetching her on a Sunday night or Sunday afternoon, from now on, your collection point is from school on Monday. And we adjust everything. So there is no point in making these people deal with each other if it's going to cause a problem. So let's avoid it completely. You fetch the child from school, and then when your time is up, you drop the child at school. Like you fetch it on Monday, you drop the child on Wednesday at school. The mother will then pick the child up from school. So they don't have to see each other at all. A lot of people who also move on, obviously, and meet new partners, also then have another challenge of not wanting their spouse to be, or ex-spouse to be in their space all the time. So when we're talking about younger children, it's good to have some sort of a backup plan, at least, in the parenting plan. And talking about backup, it's really good to have all of these things, even if you don't feel that they're relevant to you at the moment, because you never know what's going to happen. I liken it a lot to like a prenuptial agreement. Is you never get married thinking you're going to get divorced, ever. But you prepare for the worst. And a parenting plan should be the same. Preparation for the worst case scenario, that we know the child is not going to have to suffer through anything, through any discomfort at all. And that is a little bit ideal world stuff. It doesn't happen that way, but at least it helps us get there a little bit. And then the third thing that I just quickly want to touch on is maintenance. Because we all know that maintenance and care and contact are two separate issues. Parenting plans don't really have anything to do with maintenance as such, but I put it in, I put the maintenance agreement very loosely in the parenting plan just so that it's all together. Maintenance would be mediated separately, usually by a legal mediator, and it's quite an involved process, it's quite an emotional process. So I like to do maintenance mediations, a co-mediation. So one legal representative, one psychological representative, where the legal mediator will be able to explain everything properly and work everything out properly, but the psychological mediator will be there to be able to keep the emotions low or to keep them contained. So once we have agreed on a maintenance order or what we're going to do with maintenance, I then just basically take out the little clause in the maintenance of saying how much is going to be paid by which date to which bank account, and I include that in my parenting plan just so that it's all together. And once everybody's agreed on that, each party signs it, witnesses sign it, and then it gets sent off to the court.
Daniella?
Also, you'll notice, put in here, there's a little section that I've just put there, special conditions. Every case is different. Sometimes there is something that's not generic that needs to be considered. I've had a client before who was handicapped, and that didn't really fit into anything about certain instructions around the care for the child. So I put it under the special circumstances section where that also just gets stipulated.
So Daniella, thank you very much for that. It's quite in depth, and you're making me tired in the sense of how much work is involved in getting a father and a mother to come to an agreement regarding a parenting plan. It's not as simple, and it's not template based. You're 100% right. Every family is different. Each circumstances are different, and a parenting plan that will work for a mother and father with 2 children of 1, 2, and 3 will definitely not work for another father and mother of children 1, 2, and 3. It won't work. It doesn't make sense. And what I liked about what you stipulated earlier on was the parenting plan must be bought in by both parties, and it must be applicable to both parties. It must be a well-drafted document. You can't just come here with putting a few things in there and hoping that things will work out in the future. It won't work out in the future. Both parties need to think about it, discuss it, unpack it, and stipulate it in a parenting plan. Just before I get back to you, and there's 1 or 2 questions on our live chat. Back in the day, about let's say 4 years ago, there was a change in the thinking regarding the facilitator, whereby previously there was clauses in consent papers stipulating that the facilitator makes a directive, and his directive is as a court order, and you had to follow the facilitator's directive as if the court made the specific order. I think some acting judge a few years ago, 3-4 years ago, and he came with a judgment stipulating that no, you cannot give that specific power to the facilitator. I still have my reservations regarding that, because I believe under certain circumstances a facilitator should have certain power as opposed to only being a mediator, because what's the use we have all these beautiful facilitation clauses and these co-parenting, parenting coordinating clauses, but if one party does not want to follow it, and it becomes useless, and meaning you have to go back to court and litigate again. Therefore, I don't know, in my view is a facilitator should have certain type of powers. But Daniella, can I quickly, before we go on and chat, we have this 2 questions, maybe we can just deal with that because people might want to ask and add on additional information.
Of course.
Okay.
Of course.
Okay, thank you for that, Daniella. We have 1 comment. Thank you very much. A gentleman said, amazing information. You're welcome. Thank you for partaking in this webinar. We have another 1 question. Thank you for your time. Can I claim back from a medical aid if I go to a mediator? That's something very interesting because I never thought of that. I know some people, they go to the medical aid and say, we would like to have a report or a assessment on the minor child, and the medical aid, some of them pay for it. But regarding mediation, can you claim that money from a medical aid? Daniella, what is your view on that?
This is a very difficult question actually to answer, because when you talk about going to a therapist or a psychologist or a counsellor, if they are registered with the Health Professional Council of South Africa, then they are basically recognised by the medical aids. They get issued a practice number. And yes, for those sessions, you absolutely can claim back from medical aid. Obviously, it's up to the professional how much they charge, if they charge medical aid rates or not, and there might be a shortfall, whatever the story is. So does medical aid pay for mediation? The answer, unfortunately, for that is no. However, you might find a mediator that will, you might find a psychologist. Sorry, it's difficult for me to answer because it's not, I don't work like this, but you might find a therapist that's going to just write their consultation with a code that the medical aid picks up as consultation, and because they have got a practice number, yes, then they will pay for it. If you specify on an invoice or whatever mediation, there is unfortunately no, I think it's an ICD-10 code or something, there is no code for mediation for medical aid to pay back. So if you were to go to a lawyer, obviously medical aid is not going to pay you for mediation. If you go to a psychologist for mediation, technically speaking, they will not pay. But then, of course, it's up to the psychologist how they specify what the consultation entailed.
So if you have a bit of a dodgy psychologist, I don't call it dodgy, sometimes maybe a friendly one.
That's why I struggled to explain what I was explaining now. But
yeah, because obviously if mediation is not allowed, but you decide to change your codes, and the medical aid will not know. They'll think it's a normal, counselling session, a normal psychological session that took place over there. I'm with you on that, Daniella. So hopefully that will answer the question of the questioner. If you have any additional questions to add on to that, please post it. We have another question. It says the following: how do we do a parenting plan when the child is not wanting to have contact with one parent at all? So I would imagine scenario goes, the child does not want to see the mother or the father. Let's say here the child does not want to see the mother at all. How does the parents enter into a parenting plan? We do not have the age of the child. That might be irrelevant. But Daniella, what is your take on it?
So my take on that, I was going to say, it depends on the age of the child and the emotional maturity of the child. What would usually happen in this kind of a situation is, I'm a mediator that believes very firmly in child involvement of any age, so long as they can emotionally handle it. So what I would do if this was a client of mine is I would absolutely see the couple and hear each side. And then I would ask permission from this couple to be able to see the child as well, separately, without either of them, and try and kind of figure out what the actual story is, what might be going on. And then it kind of follows more of a therapeutic approach. I might then refer the child onto a child psychologist to try and figure out why they wouldn't want to. So many things could come out of that kind of a situation. It might be suitable for, let's pretend the child doesn't want to spend time with the father. It might then be suitable to, or as a parenting coordinator, what I would do is I would then kind of try and enforce therapy between the father and the child to kind of rebuild the relationship, and parenting classes and that kind of thing. But I think the most important thing to realize is that children have a say in their own lives as well. And if your child is showing signs of not wanting to be with one particular parent, I believe it would be irresponsible to force them to. But by the same time, it's irresponsible just to ignore it and say, well, sorry, you need to get to the bottom of it. Each parent has a right and a responsibility to the child. We are not going anywhere near the realm of parental alienation here. We're trying to stay as far away from that as possible. So it's not a matter of, oh, well, he doesn't want to come, so too bad. Because where does that end? All of a sudden, 5 years go, it doesn't even take that long. 6 months go by and the child hasn't seen the father. The likelihood of them reconnecting and bonding and trusting each other is very slim. So I think to intervene in a therapeutic nature at that point is probably what I would do.
Thank you for that, Daniella. The commenters regarding a question regarding the medical aid says, thank you, that's a pity, your work is so important. And I agree with that, because mediation can resolve or avoid a lot of other problems of happening. So, and it's a professional service, so I think medical aid should pay for that. But that's up to the medical
Perhaps
aid.
that's something that we'll look into. Maybe that's a little project for me to try and get medical aid to accept mediation.
Yeah, and at a good rate also. They shouldn't make it a cheap rate. You must get paid for your services. Okay. So Daniella, if I look at your parenting plan, and it's a well drafted, very simple in the sense of it does deal with all the basics. Obviously, each family is different, and another family will might add in a lot of other things in it as well. And in my view, the idea behind a parenting plan is you are the mother, you're the father, you guys are separated now, but you guys will remain caregivers of these kids for the next 10, 15, depending on the age of the child, till the child is 18 or so. Have a plan. How are you going to parent the child going forward? You know the children will be in high school in 2 years' time. What will happen then? Who will take the kids to school? What happens if one of the parties get married? So all of these things that we put in that plan. So we do not have to chat to each other at all unless it's necessary. So Monday morning comes, the child is with the dad. Perfectly fine. Mind you, often the mother collects a child, there's a plan going forward, as opposed to the parties, being involved in acrimony all the time and just going to lawyers all the time. Daniela, anything you want to pose or add to what you said earlier on?
I don't think so. I think I've spoken quite a lot. I think I've covered a lot of what I wanted to say. I think the most powerful thing that it's actually come up for me now this year in 2021, and I've also now kind of advertising in this direction, is divorce consultancy. And I think that it is so valuable to know exactly what to expect, what your rights are, which direction you can go before you start the process. And I think if people who are considering divorce actually just make the effort to try and find out what the different options are, that it could actually save a lot of hassle and a lot of emotion going forward.
Now, what I have noticed with some people, and there's obviously some people, I'm not being generalizing here, is that they just want to get divorced at the cheapest possible way, not knowing that in the long run it can cost them hundreds of thousands of rands in trying to sort out problems that should have been resolved at the date of the divorce. So people might have, for example, pension funds. They might have a lot of other things that are applicable to their marriage that needs to be resolved properly. But they're just willing to sign, and they do not want to pay the consultation fee, maybe to an attorney, psychologist, or to a lawyer, in order to assist the parties in making a proper decision. That's why the high courts are extreme, or the high courts or the children's courts are extremely busy with couples that are divorced. But the question is, why haven't these matters properly been resolved at the start? So, Daniela, your service which you're marketing is very important, very relevant, very important, because I'm willing to spend my X amount of money now at the time of the divorce to avoid stresses and issues later on in the relationship between you and ex-spouse.
Yeah, it's the same concept as a handyman. I mean, you get the cheapest handyman, you get a hinge that is going to last you for 6 months. That means every 6 months you're going to pay for a new one. If you just pay for the expensive one once, it will last you 30 years. It's the same concept. But I think what I wanted to say something now, I think that it's important. I mean, from my point of view, you can correct me if I'm wrong, but the cheap divorces really only apply to a couple that have completely come to the agreement together. Maybe they've got no children, maybe they had a prenup or whatever, that everything is already stipulated what would happen. They're both equally happy to get out of the relationship. There's no power struggle. Like for those kind of couples, then sure, go and just do a cheap divorce because there's nothing to argue about. But I mean, how many times have you seen that happen?
Yeah, you're 100% right. So the parties would have no kids, they were married, out of community property, no accrual, nothing. So you must just walk away. That's it. There's no need to fight over anything.
And they're both happy to walk away. That's the thing. Not one is not more happy than the other. They both have to be equally happy. Otherwise, it does not work.
But the moment there is property involved, issues involved, and minor children and so on, the parties need to discuss, especially if it is a joint estate. I mean, let's say a couple gets divorced at the age of, let's say, 60 years old, and there's pots and pans, there's properties, there's a lot of things, there's a married income in the property. They need to sit down and discuss, how are we going to divide this property? I'm using a simple example. Now, the same way where the kids are concerned, they need to discuss, how are we going to sort our parenting going ahead. Daniela, how do they get hold of you? On our screen, you can't see it, you on Zoom that side. It says on your website, www.danielatherapy.co.za. On that website, can they find everything?
You'll find everything. I must just say quickly that the last time I checked my website, there seemed to be a little bit of an issue connecting to it. So I'm just going to double check that. If that issue is still there, then in the next day or so, it will be back up. But yes, that everything that you need is on there. I'm very friendly. So I'm very open to email. If anybody needs to ask any advice or has any questions, you're more than welcome to email me, and I promise you I'll get to it.
Daniela, give me your email address. Do you mind giving your number and your email address? I can type it one time into the system and people can see it, or on your email address. Up to you.
Oh, never, that's fine. Have you got it?
No, give it to me quickly online. Sorry about that, man. I should have typed it in before. What is it? Fine.
So the email is Daniella, DANIELLA .Reva, REEVA @gmail.com.
@gmail.com. We got that. And the number?
Phone number 066
066
154
154
7696.
7696. Okay, got it. It's on screen.
And And I'd just like to request, if I can, if anybody would like to get hold of me on the phone, if you send me a WhatsApp, then please just let me know where you got my number from. But also, if somebody phones me and I haven't been able to answer, just please leave me a message so that I can get back to you, because I don't generally answer unknown numbers that come up, then I will. But if it comes up as unknown, so please leave me a message and I will definitely get back to you.
One quick word of advice to everyone, please, when you message Daniella or to me, please mention your name and your surname, at least your name, so you know who we're dealing with. Daniella, we have no further questions regarding the WhatsApp live, the Facebook live. Your details are on the screen. Please get hold of Daniella as soon as possible. She can, as I can hear what she's talking about, she can speak more about parenting plans than I can speak about parenting plans. Although I deal with it from a legal point of view, she deals with it from a practical point of view. You know, she's the one that's cooking the food, making the food. I'm the one that's just eating the food. So it's two different scenarios over there. Daniella, any final words before we log off? Nothing from my side? Wonderful.
I'm all good.
Wonderful. Next week we'll have another webinar with and discussing family mediation, parenting plan issues, and so on. Please, if you're online, download the parenting plan Daniella spoke about early on. The link is on the screen. And have a wonderful day. Thank you, Daniella. I'll chat to you soon. See you. Bye-bye.
Bye.
Bye-bye.